Hi, everyone, and welcome to episode 22nd of Study With Me, European Union Law. This podcast helps you get ready for your university exams and gain a deeper understanding of the subject.
Today, we are launching a deep dive into the role of the Court of Justice of the European Union, the CJEU. This is, arguably the most powerful court in the EU system.
Absolutely. And our mission today is to really unpack two big ideas that are completely linked. First, how the CJEU keeps EU law consistent and supreme.
And second, how it transformed itself into the ultimate guardian of our fundamental rights.
Which is all there in its founding mission, right?
Yeah.
Article 19 of the Treaty on European Union says the court has to ensure that the law is observed. And that came to mean protecting fundamental rights, even before they were all written down.
Exactly. And for anyone studying for exams, we're going to be hitting two key mechanisms hard. The action for annulment under Article 263.
And the preliminary ruling procedure, Article 267. These are really the pillars of judicial protection.
But the real story, the part that's actually, kind of dramatic, is the history.
Right. The aha moment is figuring out how the court went from saying we don't do fundamental rights in the 60s to making those rights the absolute bedrock for checking everything the EU does today.
It's a fascinating journey, and it was born out of pure legal necessity. If you go back to the beginning, the Treaty of Rome, it had basically nothing to say about protecting fundamental rights.
No disposition at all.
None.
Yeah.
The entire project was about economic integration. It was about building a common market. The few rights that were mentioned, like freedom of movement for workers, were just tools to get that economic goal.
They weren't rights in the modern sense of protecting you from the state.
Not at all. And that created this huge blind spot. I mean, you have national constitutions to protect you from your own government,
Right.
but suddenly there was this new layer of EU institutions making laws, and who was protecting you from them?
So what did the court do when this issue first came up?
In the early 60s. Their first response was crystal clear. Not our problem. In the Stort case, I think it was 1959, the court was asked to check an EU act against German constitutional law.
And they said?
They said no.
Flatly.
They stated they were only there to make sure community law was observed, and they were, and I'm quoting here, not competent to apply the national law of the member states, even something as important as the German Constitution.
And they didn't stop there. They doubled down on this.
They did. A year later in the Nold case, they reinforced it. They said community law does not contain any general principle guaranteeing the maintenance of vested rights. Basically, constitutional stuff is for the member states. We do EU law.
But this is where the story gets so tense, because at the exact same time, the CJEU is pushing away fundamental rights.
It's building the very tools that make EU law so powerful.
Exactly. The contradiction is just glaring.
It is. So just after saying no rights here, the court drops two bombshells. First, in 1963, von Gendenluce. Direct effect. EU law can give rights directly to people.
And then the big one.
The big one. Costa Venel in 1964. Primacy. EU law trumps all national law, even, by implication, national constitutions.
So if you're a national judge, you're being told you have to ignore your own country's laws, maybe even its constitution, to apply EU law.
Precisely. And now you see the problem. The CJEU is demanding total supremacy for its laws.
While at the same time saying those laws don't have to respect fundamental rights.
It created a massive legitimacy crisis. Imagine being a judge in Italy or Germany, countries with these brand new post-war constitutions built around protecting citizens.
You'd be thinking, why would we agree to this? Why would we let this new legal order potentially violate the rights we fought so hard to protect?
And that's exactly what they thought. This led straight to the pushback, what we now call the counter-limit doctrine.
Let's talk about that pushback. It was a direct challenge, wasn't it?
A huge one. The
Yep.
Italian Constitutional Court in Frontini, and even more famously, the German Constitutional Court in Solange, they drew a line in the sand.
What did they say?
They basically said, okay, we'll accept EU law's primacy for now. The Solange actually means so long as.
So long as what?
So long as the EU doesn't have its own system for protecting fundamental rights, that's equivalent to ours. We, the national constitutional courts, reserve the right to review EU acts. And if an EU act violates our core constitutional principles, we can declare it invalid in our country.
Wow. If that had been allowed to stand, the whole system would have fallen apart.
It would have been the end of a uniform legal order.
Yeah.
You'd have 27 different standards for what EU law means. It was a high-stakes game of chicken, and the CJEU had to blink.
So this forces the court's hand? They have to do a complete 180 to save the entire project.
A complete reversal. They had to fix this legitimacy gap, and they did it with, A pretty genius legal move.
Okay, so let's unpack that shift. It starts in the late 60s with a case called Stouter.
Right. In Stouter, the court suddenly changes its tune. It recognizes that fundamental rights are, and I quote, part of the general legal principles of EU law.
So they're not external national rules anymore. They're internal to the EU system itself.
Exactly. The court essentially co-opted them. It said to the national courts, don't worry, we'll protect these rights. They are now part of our legal order, and we will ensure the EU institutions respect them.
That's brilliant. So the fight is no longer national law versus EU law.
It becomes an internal EU matter. It's a question of balancing an EU act against the EU's own general principles on rights. Supremacy is saved because it's all happening under the CJEU's roof. Uniformity is preserved.
So what did this mean in practice? What did it actually do?
It turned fundamental rights into the ultimate yardstick. From this point on, they became the criteria for judging whether an EU regulation or directive was legitimate, whether it was valid.
So the court could now strike down EU law for violating these principles.
Precisely. If an EU act violated fundamental rights, the CJEU could annul it.
But these were unwritten principles at the time. Where was the court getting them from? It couldn't just invent them?
Good question. It looked to two main sources of inspiration. First, as it said in the International Handelsgesellschaft case, it looked to the constitutional traditions that were common to all the member states.
So the shared European legal heritage.
Exactly. And second, it looked to international human rights treaties. And the big one there, which it confirmed in a later Knoll case, was the European Convention on Human Rights, the ECHR.
So the ECHR became a kind of minimum standard for the EU, even though the EU wasn't a party to it.
That's right. And this whole evolution, this case law, eventually gets written down. It's codified, most importantly, in Article 6 of the Treaty on European Union.
Which brings us to today and the Charter of Fundamental Rights of the European Union, the CFREU.
The modern cornerstone. Since the Lisbon Treaty, the Charter has the same legal value as the treaties. This isn't just case law anymore. This is primary EU law.
And it's incredibly broad. It covers everything from dignity and freedoms to equality, justice, social rights. It's a comprehensive Bill of Rights.
It is. But for exam purposes, the most critical part to understand is its scope. Article 51.
Right. Who does it apply to?
It applies to the EU institutions, always. But, and this is a bit everyone gets wrong, it only applies to member states when they are implementing union law.
So if a country passes a purely domestic law, the Charter doesn't touch it.
Correct. But if that country is, say, putting an EU environmental directive into its national system, then anything it does in that context has to respect the Charter. The court made this super clear in the Ackerberg-Franzen case. The scope of the Charter is the same as the scope of EU law. No more, no less.
And what about limiting these rights? Because no right is absolute.
Right. Article 52 sets a very high bar for any limitation. It has to be provided for by law. It must respect the essence of the right. You can't destroy it. And it has to be proportional.
Proportionality, the classic legal test.
Yep. The measure has to be necessary, adequate, and not excessive. Basically, is there a less intrusive way to achieve the same goal? If so, you have to use it.
Now, what about the relationship with the ECHR? You'd think the EU would just join it, right? Article 6 even says it should.
You would think so. But the CJEU has been very protective of its own power. It has rejected accession twice. The main reason it gives is to protect the autonomy of EU law.
It doesn't want an external court, the European Court of Human Rights, having the final say over the EU legal order.
Exactly. It wants to be the ultimate arbiter of EU law.
Yeah.
But the ECHR is still incredibly important.
How so?
Article 52 of the Charter creates a floor. It says that for rights in the Charter that are the same as rights in the ECHR, the Charter's meaning and scope must be at least as protective as the ECHR.
So the EU can offer more protection, but never less.
Precisely. The CJEU is free to go higher, but it can never fall below that ECHR standard.
Okay, let's bring this all together with the practical tools, the mechanisms that actually let people protect their rights. This brings us back to Articles 263 and 267.
The two key routes to justice. Start with 263, the action for annulment.
This is the direct challenge.
It's the direct challenge.
Yes.
You ask the CJEU to strike down an act from an EU institution. Member states can do it, institutions can do it, and individuals can do it.
But it's hard for individuals, isn't it?
Very hard. You have to prove the act is of direct and individual concern to you, which is a really high bar. It's tough unless an EU decision is aimed specifically at you. But if you succeed, the act is wiped out, annulled.
And the grounds for annulment are things like lack of competence or, crucially, violation of fundamental rights.
There's the link. But the real workhorse, the main way rights issues get to the court, is the other one, Article 267, the preliminary ruling procedure.
And this one is the bridge between the national courts and the CJEU.
It's the absolute linchpin of the whole system. The way it works is, a normal case starts in a national court, let's say in Spain. The Spanish judge realizes there's a question about the validity of an EU directive, maybe because it seems to violate a charter right.
What does the judge do?
They pause the case, and they send that question up to the CJEU in Luxembourg. The CJEU gives a binding answer, a preliminary ruling, and sends it back. Then the Spanish judge applies that ruling to the case.
So it's this procedure that ensures EU law, including the Charter, is applied the same way in Spain as it is in Poland or Ireland.
It ensures uniformity. It's how a regular person's legal problem in a local court can lead to the CJEU clarifying a fundamental right for 500 million people.
So to sum it all up, the CJEU's journey was really one of survival. It had to embrace fundamental rights to protect its own supremacy.
It did. It moved from silence to making rights the core of its system, first through case law and now through the Charter. And it's all enforced by these two mechanisms, 263 and 267, which guarantee that right to an effective remedy we see in Article 47 of the Charter.
Great. So as a final provocative thought for everyone to take away, let's think about that autonomy again. We know the EU can set a higher standard of rights protection than the ECHR. But what happens when a national constitution seems to offer a higher standard than the Charter, and applying that higher national standard would get in the way of a uniform EU policy, like the European arrest warrant?
That is the million-euro question. And you should look at the Maloney case. The court essentially ruled that a member state can't apply its own higher constitutional standard if doing so would undermine the primacy and effectiveness of EU law. Article 53 of the Charter says national standards can be higher, but Maloney puts a limit on that.
So the question to leave you with is, in the constant balancing act between national identity and EU uniformity, just how far will the CJEU go to protect the effectiveness of its own law?
A very tricky question. Food for thought.
Indeed. Good luck with your preparation, and thanks for joining this deep dive.